Sargon has won his copyright dispute against Akilah Hughes, or Akilah, obviously, or whatever her name is, from back in 2017. And now the man is out to get some fees. Let's take a look and see what's going on. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And this is just sort of an update on a long-term case here. Like I said, this case was brought back in 2017 by Akilah Hughes. She sued Sargon of Akkad over copyright infringement after DMCA striking his video. He contested the DMCA strike, which the process is usually DMCA is filed, you contest the DMCA, and then they either file a lawsuit against you for copyright infringement, or YouTube will lift that DMCA strike most of the time. Not always, but most of the time. That's how the DMCA goes. Sargon filed his DMCA counter notification, and then Akilah actually sued him. She's like, what? Nope, we're suing him. Now, the context of this is it was over a video she made after Hillary lost the election in 2016 to Donald Trump called Why We Thought Hillary Would Win. Sargon clipped out a couple sections of that video, totaling like less than 2 minutes of time, and just played it and titled it SJW Levels of Awareness. Now, there was a whole bunch of stuff with service of process and a big mess that went back and forth, but at the end of the day, this copyright claim was dismissed, as it should be, because the judge says anyone watching this video, anybody watching Sargon's video and watching Akilah Hughes' video would understand that Sargon's video, especially given the context of who he is as Sargon of Akkad, and the title of the video, his video, which was SJW Levels of Awareness, was intended to mock and criticize the original content. He didn't use the entire amount of the video. Not that in and of itself will disqualify something, but he didn't use the entire amount of the video. He just used some selective clips to create a piece of mockery, a piece of criticism. And even though he didn't utter any words of criticism or mockery during the video, he didn't have to. Because if you watched it, you knew that it was making fun of the other video, not trying to capitalize on the commercial value, whatever that may have been, of the other video. This is a new thing. It is not a copy of the old thing. And that lies at the heart of fair use analysis, is the first prong. Is this use sufficiently transformative? In this case, the lower court said yes. So Sargon wins basically on that first issue. So I won't go into a full fair use analysis. You can find that other places, done probably better than I would do it here. So go do that. But he won on that first prong, and that's what really matters. So now he's actually filed a motion to recover his attorney's fees, which is not automatic in the copyright statute, but it is there. Let's take a look at it real quick and the main points of the document, which I have highlighted for you. And if you like these quick sort of legal recap videos or legal updates, please go ahead, like the video, share it, subscribe to the channel. And if you like more in-depth analysis with lots of mockery, ridicule, and criticism of its own, come check out my live streams, typically every weeknight at 11 p.m. Central Time, and hang out and join the community that way. Here we go. All right, so this is the motion in the District Court for the Southern District of New York, Akilah Hughes versus Carl Benjamin. That's that guy right down there, looking very unsmug. So this is the memorandum of law. Now, a motion was filed. The motion's just a very basic one-page document that says we're asking for fees. And then it's accompanied by this memorandum of law, which is filed alongside it. And that explains why they should get the fees, okay? It was filed by Wesley Mullen. That's Carl's his lawyer. And this is always nice to see. This isn't a particularly long document, clocking in around 16 pages total, and most of those are not obviously the text of the document itself, but it is nice that they put in a table of contents. This is just solid legal work. It looks clean. It helps the court to quickly assess what they need to if they need to reference anything. I strongly recommend putting a table of contents in any legal document that you filed that's over like a page or two. But if you're making arguments, especially on multiple issues, you want to have one of these. It's not necessary, but it is nice. It is nice. Here's their table of authorities. This is all the cases, and these are also the statutes and rules that are cited in the document, where they are cited, what their proper citations are. So you can find that there. But this is the important stuff. The summary of the case. This first paragraph lays out their argument. Plaintiff is a YouTube celebrity. That's Akilah. Defendant Sargon publicly singled out and mocked plaintiff to discredit her and her political positions. And they're pulling this from the complaint. So these, the reason singled out and discredit and her and her political positions are in quotes there is because they're actually from Akilah's own words in her complaint. And these words are important. They're put in by Carl's lawyer for a very specific reason. Criticism and mockery are protected expression, and they are a part of the copyright statute. In fact, in the transformative use sort of section, it pays homage to the idea that criticism is not copying. Criticism and mockery are, and parody and all of these things are part of being a transformative work. That's why he went ahead and put them in there with a notice to the judge. Look, in her own complaint, she defeated her claims. So that's a little bit important as we go. Plaintiff took offense at that, so she sued Sargon under the Copyright Act. The lawsuit was transparently an attempt to muzzle an ideological position or an ideological opponent for his critical political speech. Now, the reason they lay that out in the summary is because that is not the purpose of the Copyright Act. The purpose of the Copyright Act has nothing to do with silencing critics and everything to do with saying this person stole my work and used it for their own purposes, and they didn't have permission to do so. Making fun of someone and specifically criticizing their work is the opposite of stealing it, right? If you make an art piece and I take a photo of it and then sell prints of the photo, then I'm taking your work. I'm using the work that you made. If I take a photo of the art piece, put it up on like an easel, and I start making adjustments to it and pointing out bad technique or saying that this is an old style or whatever I might do to criticize the art piece, then I'm using your work as a reference to create something new. It's transformative. It's a basic kind of look at what transformative work is. There's a whole bunch of other stuff it could be, but that's the idea of criticism. And that criticism is its own work. And it's not just like this sort of caveat to the copyright statute. It's part of it. It's an integral part that we allow people to build off of existing work, as long as it's not using solely the artistic or whatever, the original creation on its own. It's got to be something more than that. So that's what we've got here. So here's the standard for requesting fees. So they had their summary, now they've got their standard, and then they're going to go into the arguments. The standard here, so this is their rule. In any civil action under this title, the court in its discretion may allow the recovery of full costs by or against any party other than the United States or an officer thereof. The court may also award a reasonable attorney's fee to the prevailing party as part of the costs. So this is a permissive statute. It says may. It's within the court's discretion to do so. They don't have to. Here's part of it. Here's what another court has said. When exercising discretion to award fees, courts give substantial weight to the objective reasonableness of the losing party's position, while taking into account all other circumstances relevant to granting fees. And this sentence summarizes their argument. They're going to show the objective reasonableness of the losing party's position. That's Akilah's position. And then they're going to take into account the other circumstances that are relevant. So let's see what they've come up with here. Their first argument is about awarding fees for the purposes of, or it furthers the purpose of the Copyright Act. So we've got some important quotes here. To this end, copyright assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed by a work. right? This is the idea of that transformation. And then it further goes on to saying transformative works like defendant's critical video enrich the public and therefore lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright. Fair use is part of it. It's not like a weaselly side thing. The fair use, when you have a true case of fair use, it is a new work in and of itself that would merit its own protection. Right? It is a piece of creation that, quote, enriches the public. So then we go on to the first part here. Plaintiff's claims were objectively unreasonable. Remember that quote from before, the objective reasonableness and then all other circumstances. So they're coming out and saying that her claims were objectively unreasonable. As the court determined, it was clear from the face of the complaint that defendant copied portions of "We thought she would win" for the transformative purposes of criticism and commentary. So even in the complaint that she was making, she acknowledges the criticism and the commentary that was done, and that was the purpose of the video. Not that the video was out there to steal or poach her work. Right? She was mad that he made fun of her. And that's at the heart of this case. You don't get to go copyright something or file a copyright request because you're mad that they made fun of you in the work that they created. So the next point here we have, roughly as soon as the defendant received a copy of the complaint, his counsel informed plaintiff that the claims are meritless based on the plaintiff's own admissions. This one I only bring up because this is probably the worst point in the entire document. It's not a bad point, but pointing out that the other side, that the defendant in the case disagrees with the plaintiff, isn't really helpful, because if that would merit a fee reward, basically every case on earth would merit a fee. We disagree with you. So, you know, but they're pointing out that they did try to notify her. That's the idea here. But I just don't find this to be a particularly compelling line of argument. The rest of the argument is very compelling, and that's where the focus is and should be. But they do have in there, you know, we tried to tell her that she was going to lose if she sued us. Well, yeah, lots of lawyers do that, though. So the next one, this is much more damning. Even at the initial conference, the court informed the plaintiff that her second cause of action can be easily dismissed. Now, the first cause of action was the copyright infringement. The second cause of action was she accused Sargon of lying or misrepresentation in his DMCA counter notice. And the court basically said, no, you've provided nothing to support that argument. So that's not going to be a good one. And the court warned her. Now, she could have amended her petition. She could have dropped that section. She could have done a lot of things earlier to go ahead and do that. She never really did anything that would remedy the deficiencies the court was pointing out. And one thing the court ordered initially is that in the analysis that it did, it mooted basically the idea that an amendment would remedy the circumstances. But this was well after she filed the case. When the court heard this, again, back in March of 2018, so almost 2 years ago, the court heard this and said, yeah, we could dismiss the second cause of action, no problem. She could have withdrawn the second cause of action. She could have tried to amend it and supplemented the pleading with some additional evidence of the lie or clarification of the argument, and she never ever did that. And she had lots of time to do that. So that's the first point, is whether it's objectively reasonable. And the section goes on to say, of course, this is unreasonable. She defeats it in her own complaint. She defeats it. A look at the case law would defeat it. And as the judge basically lays out, anybody looking at this would say that his work was not a copy of her work and was made for criticism and commentary, which is protected. Anyone looking at this should have known. So the next part they're going to go into, that's the objective reasonableness. Now it's all the other stuff, right? The next part is saying that she litigated, that her actual conduct in litigation was done unreasonably. So a losing party's lack of any reasonable attempt to resolve a litigation is relevant to the need in particular circumstances to advance considerations of compensation and deterrence. Akilah, in all this time, didn't propose any sort of settlement with Carl until after the judge told her that it would be that she was basically in trouble, right? Your lawsuit is weak. And so then she comes out and she demands Carl to pay her $46,000 for the infringement. Like, you go in and the judge says, this looks kind of weak. And then you're like, okay, I have a weak case. Now I only want about 50 grand. Obviously a problem with that. The courts don't want to be there. I tell this to a lot of people, especially clients. Nobody really wants to be in that courtroom. The prosecutor has something better to do. The defense attorney has something better to do. The judge has opinions to write. If they can reduce their caseload with your specific case, they're happy to do so. And they want and encourage people to find those alternative dispute resolution options like arbitration, mediation, and settlement negotiations. They want them to do that because if it doesn't need to be in the court, get it out. And Akilah didn't do that. She never offered a way for Carl to compensate her for what she thought would have been, sufficient to make up for the harm that she alleges he caused. So plaintiff made no settlement offer at all until after the March 2018 initial conference. Despite having been warned by the court that her claims lacked merit, plaintiff demanded $46,000 to resolve the case. And that demand exceeded not only any conceivable recovery by the plaintiff, but also the cost to Carl to have the plaintiff's claims dismissed on the merits. So he's like, well, I can pay $46,000 or I can pay less to an attorney to fight this. So they're making a claim Carl acted reasonably, she acted unreasonably. Now, if this case is going to cost $300,000 to fight, a $46,000 resolution isn't the worst prospect. But she asked for way more. And one of the problems is she didn't actually file for copyright protection. Now, you have copyright protection by default, but if you actually register your copyright, you get statutory protections as well. And that's that scary $150,000 civil penalty that you see is when people actually register their copyright. Then an infringement could be a $150,000 civil penalty attached. If you don't register your copyright, though, in a timely manner, specifically before some other thing happened, you may not be entitled to any of that. You'd have to consult with a copyright attorney on your specific case. But generally speaking, you need to register your copyright prior to this type of stuff occurring. So then we get into the real meat of the argument here. Her motives are contrary to the purpose of the Copyright Act. A party is improperly motivated where it asserts claims, not because of their inherent merit, but rather because the party seek to knowingly gamble on an unreasonable legal theory in order to achieve a secondary gain. So they're laying out that Akilah's got another motivation rather than just remedying the wrong of the copyright that she's alleging. And it's this attempt to silence her criticism. She went after Sargon multiple ways. She was trying to shut him down everywhere. So after filing the lawsuit, plaintiff pressed on with her censorious attack. She tweeted to her more than 100,000 Twitter followers that, quote, "This carnival barker that I'm suing for copyright infringement just got banned from Patreon. Do you think we can get GoFundMe to drop him?" Now, GoFundMe is where Sargon had put up a request to help cover legal fees associated with the copyright action in which he was a defendant. Said, hey, it'd be great if you guys could help me pay for this stuff. So she went after, she kind of is motivating people to go after GoFundMe after being dropped from Patreon. Now, we don't know if she organized the campaign against Patreon. Not hard to infer that might have happened, but we don't know that. But we do see here her basically asking followers, do you think we can get GoFundMe to drop him? I mean, that's pretty clear. Let's do it, right? The request unmistakably incites plaintiff fan base to swarm defendant off the fundraising platforms where he appealed for donations to defray the costs of a legal defense. So again, it's not about actually fighting the legal fight. It's about punishment. Punishment. We want to punish him. I don't want him to be able to pay for it. I don't want anything like that for this evil misogynist. She also suggested that they drown out fascists by bringing a speaker to play copyrighted music at their rallies, because then you can report the videos and get them taken down. And that, you know, the effectiveness of that strategy is debatable, but that is an improper use of the copyright system. That's silencing opposing political viewpoints by inserting copyrighted material into someone's existing work for the purpose of bringing it down. That's not what the court wants to deal with. That's not what the DMCA is for. That's not what any of this is about. Akilah is an idiot. That's the big problem here. So then also, Akilah used this lawsuit for self-promotion, deliberately played the case for publicity. Before filing it, she teased to her fan base on Twitter that she had a Christmas present on the way for Sargon. And she also proclaimed to her YouTube audience, "I'm suing a grown man who goes by the name Sargon." You know, self-promotion, maybe. Sargon talked about this claim as well in his YouTube videos. This isn't the strongest point, but they coincide with the fact that she was also writing a new book, and it kind of looks like she was using this to garner publicity. And that's a little tipping factor that could go in there. Again, using a copyright lawsuit or any lawsuit solely for the purposes of generating publicity, especially for something else, not raising awareness about your own situation, but using the publicity of a lawsuit to promote some other thing is also contrary to the Copyright Act, right? Like, that's not the point. She improperly attempted to extract payment in exchange for settlement of meritless claims. So she basically says in these tweets that she wants to bankrupt Sargon back in December of 2018. Very confident that she was going to win. It says plaintiff's unjustified and unreasonable settlement conduct is of a piece with her public threats to take hundreds of thousands of dollars and to bankrupt the defendant through litigation. Again, she's publicly claiming that she wants to take Sargon's monies, and that's the big problem here. It's not about copyright isn't about taking from someone else. It's about making yourself whole. They took something from you. It's about recovery. If someone steals your $1,000 laptop, the answer is not $200,000 in bankrupting of the person. The answer is getting $1,000 back for your laptop and any other costs that you may have incurred in recovering that $1,000. That's the idea. The courts are there to make whole, not make rich. So attorney's fees, here's what Carl's requesting, approximately $33,419.35. That's not very approximate. Approximately $5,000 additional costs for filing this motion. And then finally another $126 for the court reporter's fees that they incurred. So looking for just under $40,000 total. That's a pretty good rate on a copyright case, especially one that went on for almost 3 years. That's a pretty reasonable price that's gone in. He's not going out for, he's not trying to fleece Akilah here. He clearly got, this guy's in New York, and $4.46 an hour is not a bad rate at all. They didn't have to do a ton of legal work around it. They use law clerks for a lot of stuff. So they've got a reasonable request here. That's the point. They're asking for $40,000 that Sargon should not have had to pay. And that's very, very important, is that he didn't do nothing wrong. He shouldn't have to pay for not having done anything wrong. So will Sargon win the fees? That's a good question. He had a GoFundMe to help defray the legal costs. I'm guessing Akilah will raise that issue in her counter to this motion. She will try to obviously say that her request was reasonable and all of that stuff. That's going to ring a little bit hollow to the judge. It is in front of the same court that dismissed her case. So this is a motion in that. It's not a new lawsuit or anything. So we've actually got the same judge who will hear this, and he will determine whether or not he thinks she was reasonable and whether or not Carl deserves to be compensated for the stress and costs that he had to incur in all of this. And that'll be an argument. We'll be interested to see her response to this, which should be up, this was filed on February 18th. She should have a significant amount of time to respond to that. But I will be watching for it and try to update you when it comes out. Thanks for hanging out with me today. Hope you enjoyed this video. Hope you learned something, and hope you got a little bit educated on some Sargonisms. Anyway, go ahead and hit like and subscribe, and I will see you later. Peace. Peace.